Yes, Mr. Sharma.
My lord, I am back to mention item number 36 and 41.
Item number
36 and 41.
36 and 31.
41.
41. Yes, please.
Maybe taken after just after the vacation.
In item 36 and 41.
41, yes.
Give separate order, no? They would have separate matters. As prayed for by Mr. R.P. Sharma, Learned Senior Counsel, assisted by by M.S. M. Bora, Learned Counsel, in 36 for the petitioner and in 41 for the appellant, relist after
Just after vacation.
2 weeks on a date to be fixed by the registry.
After.
May I please, your lordship? My lord, I missed item yesterday, my lord, item number 55, my lord. I was coming but could not be taken up.
Order is already passed, I think.
Tomorrow, my lord, for listing for tomorrow. my lord.
No. Next.
May I please, your lordship?
Oblige.
My lord, day before yesterday, my lord, day before yesterday, my lord, your lordship was pleased to grant bail to the applicant, my lord, pending disposal of the criminal revision petition, my lord. There is, my lord, a numerical mistake in this order, my lord. Today, my lord, at home.
Right.
Deep level.
Please, your lordship. Lordship, I beg to mention item 33 of today's list.
Item
33.
33.
Yes, lordship.
Yes.
Yes, lordship, I am appearing for the complainant here. Lordship, we seek some time. We have informed the petitioner. Lordship, we
As
seek
prayed for by Mr. H. Elia, Learned Counsel, appearing for the respondent.
number 2.
Respondent number 2 with consent from the other side, relist after
Lordship, last week of July, lordship.
after 4 weeks on a date to be fixed by the registry.
Interim is there, lordship.
Interim, if any, shall continue till the next date of listing.
Lordship, lordship.
33, right, Mr.
33.
Chalia?
Yes, 33.
May I please, my lord?
Item
Yes.
number- I beg to mention item number 5, my lord. I am appearing for the respondent. I have taken the consent, my lord.
Yes, lord. And for the petition.
Madam, fix. And the
As
last week,
prayed for by MS
M. Malik.
M. Malik, Learned Counsel, for the respondent number 1 with consent from the petitioner, relist after
The vacation
3 weeks on a date to be fixed by the registry.
last week of July.
4 weeks. Okay.
Yes.
Oblige.
May I please, my lord, I beg to mention item number 14, my lord, possible for the day, list the matter after 4 weeks, my lord. There is a interim,
The
yes.
For-
petitioner, my lord.
as prayed for by Mr.
8 of the, my lord.
A. Datta, Learned Counsel, for the petitioner, relist after 4 weeks on a date to be fixed by the registry. Interim, if any, shall continue till the next date of listing.
If
Yes,
you
please.
bless me, please, your lordship. Item 37 and 38, my lord. Hearing matters, my lord, with consent from the other side, my lord.
37, 38.
Yes.
You are for the petitioner?
And is appearing for the respondent. my lord.
Huh?
He is appearing for the respondent.
You are for the
Petitioner.
petitioner. As prayed for by Mr.
And Setia.
M. Chetia in 37 for the appellant and in 38 for the petitioner, huh? Relist with consent from the respondent, relist after,
Vacation.
Lordship, can it be on 18 of July, lordship? Date may be-
huh?
18 of July, can
The
it?
date difficult, after
Yeah.
2 weeks, after 3 weeks on a date to be fixed by the registry. Interim is there?
No.
No.
Okay.
May it please your lordships, madam, item number 4, lordships. With the consent of the other side, lordships. Some
Yes.
difficulty today, lordships, can it be taken after?
It for by Mr. P.K. Garodia, Learned Counsel, for the
My lord,
petitioner.
one thing, I am appealing for the respondent.
You
in
are
this case.
objecting?
Only one thing I am like to point out. On 2 occasions, he took the adjournment.
Are you opposing the prayer
Not
today?
opposing, but.
You
as
want
the
a short
last time-
date?
As the last time.
As
in the
prayed for
first week of-
Mr. P.K. Garodia, Learned
First week
Counsel,
of
appearing
August,
for the
ma'am.
petitioner, relist on such and such date. Yes, Mr. Bhatti, which date you want? Give a date as per Mr. Bhatti's wish.
In first week of.
All right, next.
As the last time.
Point of saying in Mr. Bhatti. However, it is made clear that that no further adjournment on the request of the petitioner shall be entertained.
Lordships, there is an interim order, madam.
Interim, if any, shall continue to, then you do it like this. How, it is needless to be clarified that that in the event further adjournment is sought on the next date of listing, the interim order passed earlier shall not be continued.
Much.
Are you happy now, Mr. Bhatti?
Yes. Much online.
My lord, I beg to mention item number 18. The conducting council.
Item number
18, 18.
18.
My lord, in this matter.
Yes, Mr. Nawaz.
18, 19 and 20 are tag matters, my lord. And this has come for order. This will go for hearing. On the last occasion also, my lord, we had written to the registry and got it listed and an adjournment was taken. So
Let it be called.
let it be called, my lord.
The order matter, you wait. Yes.
May I please, your lordship, with the consent of the other side, I beg to mention item number 21, praying for it.
21.
21, I am there, my lord.
Any objection,
No,
Mr.
madam.
Nawaz?
No, my lord.
As prayed for by Mr.
Yes, Borvuya,
S.
Borvuya. Borvuya,
Bhuya.
yes.
Learned counsel appearing for the petitioner. With consent from Mr. S. Nawaz, learned counsel appearing for the
Respondent.
respondent, relist
After.
after 3 weeks on a date to be fixed by the registry.
Well, regarding item number 44, my lord, it's a hearing matter, my lord. Some accommodation for today, my lord.
Hearing, since it's a motion
Motion day.
week,
That's why, my lord.
and after reopening, this bench is also not going to be available. So if hearing matters takes time, then perhaps it will be difficult in any ways. As prayed for by Mr. S. Nawaz, learned counsel appearing for the appellant, relist
After vacation, my lord.
after 2 weeks on a date to be fixed by the registry.
I'm deeply obliged.
Item
Wait,
44. huh?
lordship, item number 42.
42, yes.
SK Talukdar, he has some personal income.
As prayed for by Mr.
SK Talukdar.
But you are not SK Talukdar.
K. Sodial.
Huh?
K. Sodial.
A. Cholia.
Sodial.
Sodial, learned counsel, on behalf of Mr. S.K. Talukdar, relist after 2 weeks on a date to be fixed by the registry.
Date may be fixed.
All right, next. Please call the list.
It is for Withdrawal, item number 45.
Yes,
Lordship, petitioner instructed me to withdraw the petition in lordship.
you are Mr. Rosid.
MD A. Rahman, your lordship.
A.
A. Rahman, your lordship.
Rahman. Heard Mr. A. Rahman, learned counsel appearing for the petitioner, also heard Mr. R.J. Barwa, learned APP for the state respondent. Mr. Rahman, learned counsel appearing for the petitioner, submits that he has received instructions from the petitioner not to press the instant criminal petition and accordingly seeks withdrawal of the same. In view of the aforesaid endorsement, the criminal petition stands dismissed on being withdrawn.
Highly obliged.
Second also same.
Yes, your lordship.
40,
6, your lordship.
46 same.
Yes, your lordship.
46 also same, huh? Disposed of.
Highly obliged.
Motion item number 1.
তুমি এখন ঠিক কৰিব পৰা নাই না নাই মানে বৰ আনকমফৰ্টেবল হয় এই হৈ থাকে যে
May I please, your lordship?
yes
Lordship, petitioner if you receive as SL and order passed by the learned principals as family court, lordship.
maintenance
Yes, lordship.
how much
7,000, lordship.
notice
Lordship, for a moment, lordship.
no let them appear
Lordship,
oh for a moment the interim shall be kept open
lordship, kindly bear one for a moment, lordship. The petitioner,
maintenance
Yes,
sorry
yes.
unless I hear the other side interim orders will not be passed
lordship,
heard Mr.
lordship, the petitioner is a physically disabled and he don't have any earning, lordship. And lordship, the learned court.
I'll give you a short date Mr. Counsel heard Mr. S.N. Krishna Tarya, learned counsel appearing for the petitioner, stop. Also, no, only private party, na?
Yes, lordship.
Issue notice, returnable date Didyog after vacation or next week to Didyog. On such and such date, registered post AD, interim to be considered. Interim is kept open to be for consideration on the returnable date, list accordingly.
Obliged, lordship.
2.
NI Act.
Lordship, my senior is on legs. Is coming from the new building, lordship. Kindly pass over a meter for them.
What is the amount?
I don't have.
Okay. All right, pass over for the time being. Yes, Mr. Vaidya?
Wait, please, your lordship. Lordship, the instant application under 528 of BNSS is for quashment or, my lord, alternatively for amalgamation with the, if I may say, the main or parent FIR in the instant case. Lordship, what had happened with regard to the same subject matter, a FIR was lodged at Patharkandi police station in Karimganj district, my lord. That FIR is at page number 29, lordship.
Page number?
29, my lord.
Yes.
The subject matter pertains to that around 214 students were appearing in a certain school, and with regard to the examination, certain discord took place. So with regard to this, my lord, I will not go into depth as of now. This FIR was lost. On the next day, in Patharkandi itself, another FIR was lodged, that is at page number 30, by a different authority, my lord. And then subsequently, in different parts of the state, my lord, including Kokrajhar district, as well as Borpeta district, as well as Sonitpur district, certain FIRs were lodged by isolated students, which form a part of those 214 original students. So, my lord, 3 of such FIRs, my lord, the petitioners had come before this honorable court for either quashment or amalgamation. And this honorable court, by the order dated, my lord, 26/5/2025 at page number 53, 3 such FIRs have already been amalgamated, my lord.
53.
Page number 53, my lord. This is a common order with regard to the Gosaigaon police station. Fifty-three, my lord. So here, my lord, the Gosaigaon police station FIR, which is identical to the instant impugned FIR, as well as to other FIRs in Borpeta and Kokrajhar PS, those have been amalgamated with the main parent FIR at Patharkandi, my lord. So this instant FIR also subject matter is completely same. This one was lodged at Dhekiajuli by the informant, my lord, which I have now come to know, my lord, that my learned friend possibly would have filed the Wakalatnama.
I've already filed the Wakalatnama.
Yeah, for the informant.
So today, my lord, I was anyway not pressing for any interim orders, my lord. So probably, my lord, there's no need for further service. I'll serve copies upon him. And lordship may pass necessary order for the matter to be listed after for admission after the vacation, my lord.
Heard Mr. D.K. Vaidya.
My lord.
Learned counsel appearing for the petitioner. Also heard Mr. S. Nawaz, learned counsel appearing for
Respondent number 2, my lord.
respondent number 2, Mr. R.J. Barwa, learned APP for the state respondent. Issue notice, returnable on give a date on such and such date after 3 weeks. 3 weeks?
3 weeks, my lord.
Mr. R.J. Barwa accepts notice on behalf of 1 and Mr. S. Nawaz accepts notice on behalf of R2. Extra copies within the course of the day, within the course of the day, list accordingly.
Deeply obliged.
I'm deeply obliged.
So it has to come for admission.
No, my matter may come for admission because there's no service required.
This is not
further
because
service
have already appeared. It may come up for
Well,
admission.
for
or
admission.
interim for admission. That may be considered on the next day.
List, he's saying it.
Yes,
No, no, because you are saying-
because I was already stated.
List for admission on such and such date, interim is kept open for consideration on the next date.
Deeply obliged.
Mr. Vaidya, if you have opponent like Mr. Nawaz, there is no problem.
My lord, that has been helpful for more than a decade,
Correct.
my lord.
Deeply obliged, my lord.
Number 6.
Charge sheet FIR quashing,
No, Lord, actually something different.
something more,
Something different.
something different.
Yes, Lordship, I am petitioner responded to was my wife. She lodged the FIR against me. Thereafter it was charge sheeted. We are under bail. Then during trial lordship, all evidence were adduced. Thereafter they filed a petition for calling other person who are not named accused in the charge sheet. Then lordship that petition was rejected by the trial court. Against that order, informant came before your honor for challenging the order in that matter. Criminal petition partly allowed. Petitioner's younger brother and father. After that,
Younger brother has?
younger brother and father, these two was included. Then he went to Supreme Court with SLP. Then lordship, there's some development by the petitioner and respondent too. Then we made in some MOU and then there's a mutual divorce. In the said mutual divorce and MOU lordship, there are some lordship condition that both the party will withdraw their respective cases. So according to my British petitioner brother, they withdraw all the cases. Send
You are for the wife or the husband?
I am from the husband. Yes, husband who is the wife who lost the FIR against me.
You are for R2, Mr.
Yes.
Khandikar.
Yes.
Mr.
yes.
Khandikar. You are for R2.
Yes, respondent to this. So my brother and all the cases that we have, we withdrawn. But the thing is that the FIR 498A, it is pending.
Fire?
FIR
498.
yes, that is pending. And in the MU, it was a part of the decree. While passing the divorce, divorce.
So
that-
this 498A FIR was also part of the condition that it would be
Yes.
withdrawn.
Yes, Lordship, I'm coming. That
Is that
the-
an admitted fact,
Yes, Lordship.
Mr. Kandikar?
By kindly draw your lordship kind indulgence to the page number 56,
Yes. Para 3.
para number 3.
56.
Para 3.
Yes, please
Seven
read.
Number, para 3, line 7.
please.
Shall put her sincere efforts and shall take all necessary steps for lawful acquittal of the first part. Since 498 accusation is a non-bailable and cognizable, not compoundable, what it means lawful acquittal? Already we have executed, I have no manner of hesitation that the mutual understanding was executed between the parties. It was landed with the learned court below. Now it is open to the learned court below to pass whether the case may be resulted to conviction or it may be acquittal, it doesn't matter. It's a criminal petition.
What is the status of the 498A?
It is evidence closed, Lordship.
All
All the evidence closed.
Evidence closed.
Closed, yes.
Now, this order was placed before the criminal court,
Yes, Lordship.
and
It was-
the
yes.
wife's evidence has been taken.
Initially, it was taken.
Later on,
Later on, court passed the order and someone was issued, but the respondent did not turn up before the court.
turn up.
Yes, Lordship, I'm gonna coming.
You see, you wanted what, Mr. Khandikar, I understand what you are saying. But then if the intention of the wife is to settle the matter, then she should appear before the court below and tell whatever she wants to say. And based on that, the court will take a call. Isn't it, Mr. Barwa? What else can be done otherwise?
The parties that compounded the. Yes,
Correct.
Lordship, again, I'm coming, page 60.
One sec.
Yes, sir.
I think,
498 is the compounded law.
correct. So since it is already there,
Yes.
now it appears that she has not appeared after being summoned. So let her appear.
Lordship,
Yes, Mr. Khandikar?
Since all the PWs were introduced by prosecution, 319 application was
That is a different aspect. Now, what is the wife? What does she has to say? Whether she is agreeable or not, she has to say before the court.
lawfully acquitted, lawful.
Counsel,
Lordship, please.
now
this line. Lordship,
let us not get into the twist of these compromise, because what she understands, how she understands is not before this court. It appears that both parties have agreed to settle the matter. This much is evident.
Lordship, next.
Now, after agreeing, now when the court is issuing summons, if she doesn't go, that goes against the very compromise.
We did not receive
So-
any summon, my lord.
Lordship, yes, I'm coming.
Page.
Yes, coming. Sir, this page 56, same para, last line, Lordship. Of the first,
rest-
all other accused person of GR case number so and so by appearing in person before the honorable court of CGM, and oblique or as and when summoned. The response of withdrawal of so and so. Lastly, I'm coming. One line is there. If you will measures. She will take all necessary steps for acquittal. Lordship, please come page 60, when decree of divorce was passed.
One sec.
Yes, Lordship.
The wife is an accused person.
No, Lordship.
She's not.
No, she's not.
So this appearance is the accused person's.
Yes, Lordship.
And the responsibility of to withdraw the MS so and so and
And
SLP so and so
SLP
at the instance of so and so and so and so is on the first part, yeah?
Two cases we withdrawn.
We withdrawn, you
Yes.
have withdrawn. Yes, page.
Then Lordship come, after this agreement, there's a divorce. In divorce, but divorce was mutually allowed. In divorce page 60. But thirdly, Lordship, considering the facts the parties have agreed, dissolve their marriage by mutual consent so and so, and have laid down the terms and conditions by entering into MU dated so and so. Hence, this court feels that there is no impediment in allowing the prayer for dissolution of marriage between the parties, by again degree of divorce of mutual so and so. Last line. Thus, marriage between the parties, Dr. Pathora and Bernalista and dissolve. The MU dated so and so shall form a part of the degree, Your Honor. So part of the degree is the duty of the respondent to comply.
That
Yes,
is all
yes,
right.
next I'm coming,
I am
sir.
not on comply,
Yes.
but now where was the summons issued and she
Yes,
has
sir.
not appeared? Show me that.
Then Lordship, after when she's not coming, then we file a petition. When she's not coming, we file a petition before the court. Yes. We file a petition before the court, calling her to come before the court. That is, our petition is page 65. petition C11, we filed Annex 13.
Prayer at 67. Admit this petition, issue summon to the informant to appear before
Yes,
this
yes,
court
yes.
for re-examination.
Yes, Lordship.
Yes,
this
what
is the-
happened then?
This is the status. Then as per instructions, she was summoned, she is not turned up.
Where is that order?
That was not enclosed, but so my
No,
instruction.
no, you give me that order because if summons has been issued, I would have,
Yes.
uh,
Yeah, yes. Lordship,
I'm
but-
fixing it on the reopening.
Yes,
You
sir.
get a certified copy of that order.
Lordship,
My lord.
I'm coming, sir.
I may kindly be
Let's-
excused for the interruption once again. This is a fourth criminal petition is.
It's all right, Mr. Khondikar, I'm not passing any order today. Let that order be put on record. We shall consider thereafter.
Lordship,
Mister, your name?
Lordship, let me say one, Lordship.
No, nothing more. Mr. Dilip Roy.
Dilip Dey, Lordship.
Dilip Dey, learned counsel appearing for the petitioner submits that despite the matter being compromised between the informant and the petitioner, the informant has not appeared before the proceeding under section
498.
498 capital A before the trial court. However, the order issuing summon to the informant is not on record. Let the same be brought on record on the next date of listing. Relist on such and such date. When can you come, Mr. Khondikar? You stay at Nagaon.
No.
When? Give me a date. Yes, date Didyok.
After your lordship.
Mr. Nawaz? Amicus. You are there in 7?
In each your lordship as a amicus.
Yes, because 7, I don't think anybody is there.
Well done.
Heard Mr. RJ Barwal at APP for the state. Only one respondent, no? This is out of which provision? Mr. Barwa, you have the papers.
No, my lord, this copy is not furnished to us, madam. It's a JLA bill.
The second copy আছে নাকি? Three zero four B IPC. Admit. And then same, Mr. S. Nawaz, learned counsel is appointed as an amicus curiae to represent the appellant in the appeal. Call for case records from the court of the additional session judge Borpeta. Stop. And when you said issue notice, na? Did we say issue notice? Admit, issue notice. Mr. So-and-so accepts notice for the state respondent and then say Mr. Nawaz, huh? So-and-so. And scan copy, let the copies of the appeal memo be furnished to Mr. Nawaz, learned amicus curiae. List after 3 weeks, returnable 3 weeks, then list accordingly.
The copy may be furnished now.
You also. Copies of the appeal memo to both Mr. RJ Barwa as well as so-and-so, huh?
I'm deeply.
By this application, my lord, I'm praying for quashing of the proceedings.
138 proceedings. Yes.
So my prime contention.
Amicus curiae, Ms.
I am
Priyanki Das.
Yes, your lordship.
You are the appointed as an amicus?
Yes, your lordship.
For whom?
Respondent, your lordship.
So, Lordship, we are appearing for the respondent who have submitted wakalat number.
Mr. Poddar, you are appearing for the
Respondent number 2, Lordship.
point number 2.
Yes, Lordship. Yesterday we have
And
submitted wakalat number.
You were appointed earlier for R2.
Yes, your lordship.
Then I think we can release Ms. Das, or if you want, you can still assist. More the merrier. Yes, Mr. Poddar, what do you say?
I have no objection, Lordship. If she has every
Yes.
let the
It is up to you, Ms. Das.
Yes, sir.
If you are,
let her name be there, Lordship.
you can be there.
Yes, sir.
Anyway, then, Mr. Poddar, since you have now appeared, so we will fix it on another date
As your Lordship.
because you.
I am ready to hear if Lordship hears the matter. I am ready here, Lordship.
What is the matter? Why has it come today for admission?
My lord.
Where is the FIR? It's a criminal quashing.
No, my lord, complaint case. It's a private.
Plain case. Where is the case?
My lord,
Cognizance have been taken.
Case number 15, my lord.
Ba?
15, my lord.
1-5.
My lord, in this matter, first, I have two contention, my lord. First contention is that, my lord, the notice, which is statutory notice, my lord, which has not been served upon me, my lord, as the same has been returned due to insufficiency of address, my lord. Which is, so no cause of action arose for 138, and they have admitted in their complaint as well as in their evidence on affidavit also.
Proceedings have been stayed? No.
No. My lord, already the complainant has been examined, cross-examined.
So one of your ground is that there is no cause of action.
My lord.
Yes.
Then, my lord,
138 to the go. NI. Yes.
and second contention is that, my lord, the reason for which the check got bounced, my lord, it does not attract 138 NI because the reason is no such account, my lord. So
Reason is
no such account, my lord.
no such
Account.
account.
Yes, my lord. If the account is not maintained by me or by the bank, my lord, so 138 will not attract me. It is the first condition which has to be satisfied.
Yes. Let us read the complaint.
Complaint, my lord, page number 15, my lord.
16, I think it starts.
Yes, my lord. May I read? The complainant is a proprietor firm situated at Barapara, Ward number 21, near Shahid Bedi, PO and PS district Bongaigaon, Assam, which is represented by its proprietor Sri Mitul Methi, who is residing at Barapara, Ward number 21, near Shahid Bedi, PO and PS district Bongaigaon, within the jurisdiction of this honorable court. The accused is also a proprietorship firm represented by its proprietor Sri Keshav Gogoi, who is residing at so and so Nandanagar, house number 11, Guwahati, PO dispute and district Kamrup Metro, Assam, which falls outside the jurisdiction of this honorable court. The accused have purchased some sanitary materials from the complainant amounting to rupees so and so only through valid challan, and the accused have paid the said amount to the complainant by way of check. The accused have issued a bearer check bearing check number so and so dated 27/4/21 of the United Bank of India, Khanapara, Guwahati branch, amounting to rupees so and so.
Mr. Counsel,
My lord.
whether the statutory compliance have been done or not, these are matter of trial.
Yes, my
Why
lord.
should this
Yes,
court go into this aspect at the quashing stage?
Yes, my lord.
The evidences have already been taken.
Yes, my lord. Initially, this matter was dismissed, my lord, by the trial court. Then they have preferred a revision, which has been allowed, my lord. That an agreement was entered between.
I am not giving you any interim today. I may, if you want, I can admit and post it for hearing.
My lord.
Mr. Poddar, I'm admitting and posting it for hearing.
No problem. My lord, as there is no stay, my lord, a date may be fixed, my lord. Kindly, that is my prayer.
This question is not maintainable, Lordship. As your Lordship has stated that.
I'll keep that question open.
To be,
My lord,
let the
I'll
question
keep
open.
that
We have
question
no objection. Let the question open. Let
But
the
you
trial
see, you
court
look
decide.
into it. I'm not dismissing it right away.
yes, my lord.
Otherwise, I would have dismissed it right away. Today being the second last day before the vacation, I thought, let me not
Court and bench
dismiss
of
it.
this court has held that in this sort of matters, petition
It's a
is
matter of
not
trial.
matter of trial.
It's a trial.
Let
No,
the
my-
matter open, whether
No, my
notice
lord,
is
when
served,
there
notice
is
is
no
not
account,
served.
when there is no account.
Anyway, heard Mr.
H. Ali.
H. Ali, learned counsel for the petitioner, also heard Mr. R.
Escape Poddar.
S.K. Poddar, learned counsel appearing for respondent number 2.
Yes, Lord.
And MS P. Das, learned amicus curiae for R2, as well as, yes, any state counsels there?
No, my lord. Only one.
So pretty private.
The matter requires full-fledged hearing. Scan copies, sir? The scan copies, as called for, has also been, has been received. Matter requires full-fledged hearing. Admit no formal notice as parties are represented. List for hearing, in the month of September.
As your lordship, my lord, earlier date, my lord.
Date.
Yes, there is no.
What date? Registry will give you the date.
As your lordship.
Okay, give a date in the month of September. List for hearing on such and such date. It is needless to be kept, needless to be clarified that the issue of maintainability of the criminal petition is kept open.
Obliged.
Item number 9.
Ms. Das, you also assist on that part
Yes, sir.
because that is the two grounds for quashing. The principles of quashing is well settled. This court cannot go into all these aspects.
Deeply obliged.
9 is criminal. Ms. Das, please be here. Admit. Issue notice, Mr. R.J. Barwal at APP for the state accepts notice for the state respondent, MS Priyankhi Das, right?
Yes, your lordship.
Is appointed as an amicus curiae to represent the appellant in the criminal appeal. Let copies of the appeal memo be served to both the learned counsels by the through the registry. Call for scan copy of the, I think here it will be the case records, right? Call for case records.
LCR.
You don't use the word L, TCR. Call for the trial court records from the, from where? From the Learned Court of Session Judge, Karbi Anglong, Diffu. Notice of no returnable 4 weeks per year, list accordingly.
I'm deeply obliged.
Let the name of MSP Das be reflected in the cause list.
Next one also there.
Yes, huh?
Next one is also there.
Next one is also same. All right, in item 10 also you make it same order, Ms. Das.
I'm deeply
Yes.
obliged.
Item 11.
Mr. Nawaz, that matter where I had appointed you as an amicus, you remember the number?
Juvenile appeal, item number 7.
7. 7 to tie Luisla. I think I forgot to mention cause list dot naam dekha bole.
May I please order, see?
Item 11.
11.
Yes.
Was it appellant was convicted?
Scan copies of the first time.
Was it first time?
Admit issue notice. Date is there.
Was it?
Mr.
This one, no one.
R.J. Barwa accepts notice on behalf of R1, extra copy. R2 by registered post AD within 3 days from today. Call for the case records from the court of
Was it,
the additional session judge Sipsagar. 4 weeks corrigible, list accordingly.
Was it, and there is an IF for suspension of the sentence.
I also issue notice.
Deeply obliged.
Yeah, please, your lordship. Lordship, it is criminal appeal, lordship. POCSO matter, lordship.
Same, huh? Notice. R2 informant.
Yes, lordship, informant.
Huh?
Informant, lordship.
R2.
Yes.
Okay.
Complainant and informant.
And case records from
Lordship, special judge POCSO Golaghat.
special judge. So, IA is there?
Yes, lordship, suspension and.
Okay. Notice and IA also, huh?
Till then.
Yes, next.
Item
Obliged.
12.
Pass the matter for a time being.
Huh?
Pass the matter for a time.
I'm being.
Time being.
Okay.
Item 15.
Also, can you pass around after time being also?
All right. হৈ গ'ল নেকি admissions? Supplementary আছে না? Yes, Mr. Kaushik,
I'm sorry, my lord, I was
that's all right. You don't have to be sorry.
lordship here, the first my grievance is
Huh?
that my first grievance in this petition is that the summons which was issued in the complaint case, my lord, was presumed to be served.
Was
And-
presumed to be served.
Served. And accordingly, thereafter, on absence, a non-bailable warrant was issued firstly on 4th of February 2023 and consequently in the rest of the subsequent orders, my lord. So what I'm praying for, my lord, I have very limited prayer. Lordship will suspend the summons, the non-bailable warrant issued against the petitioner and allow the petitioner to appear before the court, my lord.
During pendency.
During-
Yes, Mr. Barua,
Sir,
not a party.
the complaint case, my lord.
Mr.
The order-
Whether IPPs are parties or not, in every criminal matters,
Okay.
I feel their
Their assistance
is required. Yes, where is your prayer?
My lord, my prayer is at page 11.
Why did this occasion come wherein the bailable warrant of arrest and
Bailable warrant was
NBWA,
issued, my lord. In the first instance, it was NBW was issued.
why was it issued?
It
Where is
was-
that order?
My lord, that is page 24. 4th of February 2023.
Absent without steps. Complainant has also submitted the postal receipt and so and so. Perusal of the same. Thus, considering the summons to be duly served, I deem it fit to. So immediately after summons were served,
The first-
directly NBW.
Directly.
Then it can be, I think, pen,
Just completing the process, my lord, NBW cannot be issued, my lord.
correct.
But what I have found, my lord, someone is duly served, my lord. But he has not appeared before that court.
I am not going to dispose it. I will simply say that let him appear.
Yes.
130 matter, my lord, so.
Let him appear, and on that date, till then, the NBWA should be stayed,
Captain Eben.
kept in abeyance.
That's also may dispose of the matter, my lord.
In fact, lordship can dispose it, my
The
lord.
only problem disposing is that the respondent has not come.
My humble submission, my lord, it will not affect the other respondent.
It will not.
Only because if he is not appear, my lord, trial will delay.
All right. Heard Mr. B. Kaushik, learned counsel appearing for the petitioner. Stop. By way of this revision petition under section 438 and 442, read with section 528 of the BNSS 2023, the petitioner is seeking setting aside and quashing of the order dated 22/2/21,
First,
wherein bailable warrant of arrest
deeming it, the summons was served.
was issued against the accused petitioner and the impugned orders dated 4/2/2023 and 34/2025, wherein non-bailable warrant of arrest within bracket NBWA was issued against the accused petitioner. Stop. The brief facts of the case is that on 9/6/2025, paragraph 2, 3, 4, 5, no, 3 लेके लिख दिया. 4, 5, 6, 7. Mr. B. Kaushik, learned counsel, submits that as the records reveals that on several occasions, taking into account of the absence of the petitioner without any steps, the trial court issued bailable warrant of arrest. That's what you were
Not
saying.
available.
No, initially,
First day it was available warrant.
but
When the,
deeming that it was served.
it was served.
Mr. B. Kaushik, learned counsel appearing for the petitioner, submits that the trial court, by presuming that the summons has been served, issued bailable warrant of arrest against the petitioner, and the same was continued by several orders. He further submits that thereafter, non-bailable warrant has also been issued. He further submits that the petitioner is ready and willing to appear before the trial court on the next date of, when is the next date?
Next date is not shown in the e-code.
Before the trial court within
30 days.
no,
Well,
not
it is
30
from
days.
Tripura.
2 weeks.
In
from
2 weeks,
Tripura.
let him come. Or I simply issue notice. Your choice. You want to come, you don't want to come. Within 2 weeks from today. Absolutely. In view of the aforesaid assurance given by Mr. B. Kaushik, learned counsel of the appearing for the learned counsel representing the petitioner, this court deems appropriate to dispose of the instant criminal revision petition at the motion stage before issuance of notice in the interest of justice, and accordingly does so. It is hereby directed that upon the petitioner appearing before the trial court within 2 weeks from today, i.e. 2 weeks of the date of the dialogue, i.e. such and such date, বন্ধ হয় নেকি এইটো চাই ল'ব, within কৰি দিব হা। 21st July so and so, comma, which is the order, NBWA order?
The last is 30th
the
2020.
Trial court shall consider, shall proceed with the matter, and upon such appearance, the orders dated 4/2/2023 and 3/4/2025 issued by the trial court shall be kept in abeyance till then. I think that is sufficient. Ordered accordingly, disposed of.
Great one.
Item number 7.
You know, dispose of the two as well.
Your Lordship, yesterday, learned PP took time to
Three
go.
to key hole. Three to hole. Yes, Mr. Thakur.
Lordship, yesterday, learned PP took time to go to the brief here.
Yes. Yes,
Yes, your Lordship.
Mr. Barwa, are you ready? Huh?
It's relating to custody of a.
No, my lord, may kindly see, my lord, the page number 66, my lord. May kindly close the page number 66.
66.
6, my lord, yes.
Yes.
67.
My lord, may directly come to page number 67, my lord.
This is Jima of what?
Jimma of your Lordship, some your Lordship brass materials and copper, your Lordship.
Yes, 67.
My lord, from the middle portion, my lord, I am just reading. As such, the said articles cannot be given in Zimma of the Zimmadar at this stage. Send the report and take it with the case record. Considering the report, the Zimma petitioner is directed to appear before the investigating officer with proper documents claiming ownership of the same, and thereafter, on being satisfied, the IO shall release the said article.
Yes, you appear.
My lord,
Your
that was
lordship-
the order, my lord, let me submit. That was the order passed on 15/10/2024. my lord.
Yes.
Therefore, my lord, there is no report that, my lord, whether he appeared before the.
Lordship will kindly see, that's what I have submitted last occasion also, your lordship. Your lordship may kindly come to page 127. Now, there was an earlier order, your lordship. What has happened, your lordship?
127.
127. Here what has happened, your lordship? By this order, learned session judge, your lordship, rejected my prayer for your lordship, Jimma, your lordship. Now, what has happened here, your
So
lordship?
this order is of 16/11/24.
After passing of the first order.
First order, that's why, your lordship, that has created problem, your lordship, and this happened, your lordship, there are two petitions, your lordship, filed.
One second. By 16/11, what has happened?
It was, my prayer was rejected.
After consider the documents and all that, after verification.
No, my lord, that
No.
is not clear, my lord. That is what I am submitting, my lord.
Not clear.
15/10/2024 order is very clear, my lord. I will directed the party, my lord.
Let me
to
submit, let me submit.
No, but then how do we know whether it has been verified, not verified?
Lordship. No, your lordship, what has happened, your lordship will kindly come to page 31 first, your lordship.
No, otherwise, to cut it short, if that is the issue, then we can always say reconsider upon
Lordship-
proper verification.
Lordship, that your lordship can say, your lordship.
So we have to call for a report, my lord, then.
Huh?
We have to call for a report, my lord. Whether this article, my lord.
No, if you have to call for a report, then we will do it right away and post it after the vacation.
Yes, my lord. That can be, but already search sheet has been submitted, your lordship. Probably your lordship investigation is already complete. So I report.
So the report will come from whom then?
Then, my lord, if the search is submit, my lord, then, my lord, it is before the appropriate authority, my lord, whether trial is going on, my lord.
So why should we not dispose it of with direction to the trial court to consider
Lordship.
afresh
That can be done.
in accordance with law?
In accordance with law, my lord.
Lordship.
Isn't it?
Lordship.
That can be also done.
But for that purpose, my lordship, we will have to set aside the order, my lord. Now, when lordship will set aside the order, there has to.
So then what, all right, Mr. Barua, just tell me what is to be called.
My lord, now, my lord, since it is searched, my lord, searched matter, my lord. That means investigation has been completed, my lord.
To scan copy,
Materials has been found against the petitioner. my
that is a different
lord.
thing.
Yes, scan copy may be called for, my lord, we'll verify, my lord.
Scan copy already called for.
No, but that doesn't have any report.
And lordship will kindly, I have annexed this.
Mr. Barua, you see, both of you are not assisting me in what order to be passed. The court wants to
Lordship, my prayer will.
give you the order, but what is the order to be passed? Please tell me.
Lordship, my prayer will be, your lordship. Your lordship, what has fallen from your lordship mouth, let the matter be remanded back to the session judge, your lordship. He will look into it again, your lordship, and at this stage, your lordship, if it is.
No, now the order that is under challenge before this court is which one?
Page, your lordship, 127. And in fact, here, your lordship.
Which admittedly, whether it has been verified or not is not discernible, correct?
Lordship.
So on that aspect,
that
I am on that, my lord.
I'm also on that.
Passing the first order, my lord.
Correct.
Whether he appeared
So
before the.
therefore, I'm saying that since the second order does not reflect whether this has been done or not, so let the matter be remanded back for the trial court to verify all this. Whether he appeared, whether the documents have been given, and then to pass a reasonable order in accordance with law.
Lordship, that's what my prayer.
Isn't it, Mr. Barua?
My lord.
Otherwise, what is the use of keeping these
Lordship.
matters? The Jima, the already charge sheet is submitted. What is the
Secondly, my lord, he is paying for interim Jima. But interim Jima in some articles cannot be
No,
given.
no, interim, we are not,
It is not
this
a
court
great
is,
one that-
this court is not going to give any interim order today.
That way, your lordship can dispose of your lordship, and in fact, your lordship.
Okay. Heard Mr. S. Barthakur, Learned Counsel appearing for the petitioner, also heard Mr. R.J. Barwa, Learned APP for the state respondent. By way of this petition, under section 528, read with 438 and 442 of the BNSS 2023, The petitioner is seeking setting aside of the order dated 16/11/2024 passed by the Session Judge Jorhat, whereby the petition number 318/24 filed by the petitioner for seeking jima of 106 bags of scrap copper of 16 kg in each packet and 105 kg of brass materials consisting of 3 bags seized in connection with Jorhat Police Station case number 199 of 2024 was rejected. The brief facts of the case is that pursuant to an FIR dated 25/5/2024, lodged by one Shri Kaushik Kalita, APS Deputy SP P. Jorhat, alleging inter alia that they have received credible information from a source that some stolen materials consisting of copper and other materials were being concealed in a scrap dump at Singali Gaon, Jorhat, which is owned by one Maniuddin Ahmed, upon preliminary inquiry conducted, it was revealed that the said scrap dump is owned by one Siraj Ali, and they purchased those articles from various dumps. On the basis, it is the specific case of the prosecution that on the basis of the said FIR, a case is being registered and numbered as Jorhat PS case number 199/2024 under section 379-411-413 of IPC. It is the further case of the prosecution that on 25/5/2024 itself, the investigating officer seized the following articles from dump of Sahar Ali and accordingly prepared Caesar list in presence of the attesting witnesses of the following items. Page number 4 of Paba, quote unquote corrective items book. The present petitioner being the owner of the aforesaid materials, on 3/6/2024, filed a petition bearing number 318 before the Chief Judicial Magistrate Jorhat under section 457 of Criminal Procedure Code, seeking custody of the said seized articles. However, oh no, don't say that. Thereafter, during pendency of the aforesaid petition, on 7/6/2024 and 13/6/2024, who submitted some document
from the petitioner side.
petitioner side only? I have not understood this paragraph 6 of yours.
Line is yours. It is by the petitioner, people from belong to the petitioner.
But this is not relevant.
Lordship.
Is it relevant?
It is because, Your Lordship, after this seizure, Your Lordship, we file 590, Your Lordship, another petition for custody, Your Lordship.
It appears that pursuant to the aforesaid petition, upon the petitioner submitting some documents, the investigating officer prepared another Caesar list, and the petitioner accordingly filed second Jima petition being petition number 590 of 2024.
That was disposed of by order at page 66, Your Lordship.
The one which you have read.
Lord,
The aforesaid petition by order dated, where is that order?
page 66, Your Lordship.
The aforesaid petition was
67 is the relevant part, Your Lordship.
disposed of by the trial court by order dated 15/10/2024
Lordship.
by directing the petitioner to appear before the investigating officer with proper documents claiming ownership of the seized items, and thereafter, on being satisfied, the IO to release the seized articles to the actual owner in accordance with law. However, it appears that subsequently the order 16 is passed in which petition?
Earlier petition, Your Lordship.
However, subsequently the first Jima petition was placed, had come up before the learned trial court, which was rejected. Which was rejected. Stop. Then you say Mr. Barthakur submits that it is not discernible from the order dated 16/11/2024 as whether the trial court has, as whether the appellant, the petitioner was given the opportunity of appearing before the investigating officer, and the document submitted by the petitioner has been verified or not. Stop. Then you say heard, perused, apt to reproduce order dated 16/10/2024, which reads as hereunder, page 66. Relevantly koi diba, A to A. Reading of the aforesaid order, it is clear that upon the report, upon perusal of the report submitted by the investigating officer, the trial court directed the petitioner to appear before the investigating officer with proper documents claiming ownership of the same. And thereafter, on being satisfied, the IO shall release the seized articles to the actual owner by observing due process of law. Stop. The order passed in Jima petition number 590/2024. Apt also to reproduce the impugned order 16/11/2024 passed in Jima petition number
There is 318 of 2000.
318 of
2020.
2024, which reads as hereunder. Perusal of the aforesaid indicates that the charge sheet has already been submitted in the case. And the Jima application has been rejected by the trial court, primarily on the ground that if the same is required to be exhibited by the prosecution during the trial, the prosecution would be handicapped and prejudiced if these are released if these are released to the accused petitioners. Stop. You want to say something?
My submission will be recorded, my lord, since charges has been submitted, my lord. So question of giving Zimba does not arise, my lord, at this stage. That submission may be recorded. So charges submitted means, my lord, there is materials found in against the petitioner, my lord.
No, but the scan copy doesn't say anything. On what? Because it appears that only because charge sheet has been submitted,
Yes, but trial court, my lord, observation is this, my lord, that since the materials will be
I have
required.
seen, I have seen that. I've just quoted that part.
This is the observation of the trial.
Lordship will kindly see, your lordship, that is the problem with this order, your lordship. Based on a presumption, your lordship, that cannot be rejected.
No, but Mr. Bhattakur, now that I have read the brief, it appears that there are two petitions.
Lordship.
One was the first petition, which was pending. While that petition was pending,
Other order is passed.
no, because you filed another petition,
Lordship,
and
that-
that was in relation to some other documents. There are two Caesar lists.
Lordship.
So as far as the second Caesar list is concerned, there is an order of the trial court that upon proper verification, appearance and proper verification, the investigating officer will do the needful.
Lordship.
However, in the first case, there was no such order, and this is the impugn order which is charge sheeted. So things are not very clear. This has come today for admission. This
Lordship.
matter will need a full-fledged hearing. I think in the meantime, let the scan copy of the, what has come, have you seen?
I have seen, my lord, yesterday, not,
Entire updated scan copy is required.
Up to that may be called for, my lord.
Admit, no formal notice as parties are represented. Up-to-date scan copies be called for, list for hearing in the month of August 2025.
Your lordship may fix a date, your lordship.
Yes, next.
Because your lordship problem is this, your lordship. this
Yes,
is
next.
Maybe your lordship. Like, maybe your lordship, that's what our the apprehension is, your lordship.
Yes, next matter, please.
Oblige, your lordship.
My pleasure, Lordship. Lordship, in this
Transfer
case, the
petition.
is paid before the Lordship for the transfer of the FC criminal.
Who is
case number-
appearing for the respondent?
I think Mr. D. Bodole,
This is item number
48, my lord.
48. His name is shown. Right,
Last
after
occasion-
vacation,
on Last occasion, he has appeared, Lordship.
there's heard Mr.
P. Das, Lordship.
P. Das, learned counsel appearing for the petitioner, none appears for the respondent despite name being shown in the cause list. However, let the matter be relisted immediately after vacation on such and such.
Lordship, the interim order passed earlier may kindly be.
Interim order, if passed earlier, shall continue to the next.
Lordship, Lordship.
Okay, after 2 weeks, they did it. They, after vacation, khula, after 2 weeks.
49.
Hi, please, lordship.
Yes, Ms. Wrong me,
Yes, lordship.
wrong May.
Wrong mail, lordship.
Yes.
Lordship, my prayer of the Jima prayer, lordship, was rejected by the trial court, lordship. which
Why was it
27.
rejected?
That's also the,
Why rejected?
lordship, 3/9/2024, lordship.
Where is that order?
Last page of 27, lordship.
Vehicle,
Yes, lordship.
27.
Page 27. Annex 3.
What is this ground of rejection? Who is appearing? For the other side, Mr. Sharma? It appears that the seized vehicle was knowingly used for transporting the recovered alleged contraband. Hence, I do not find merit in the instant petition seeking Jima of the seized vehicle.
That is, the vehicle was used.
Yes, of course, vehicle, that is the allegation, but do you need that to be now kept in the custody? Sundarbai's case?
Yes,
Yes,
lordship.
my lord.
What do you have to, what is the use of keeping this vehicle? Contraband articles have already been seized.
My lord, kindly fix after some time, my lord, I am told to my lord that.
Have a look.
Lordship, to that third occasion, lordship, they're taking time for the.
No, my lord.
No,
that's-
no,
that's-
After some time.
Item number 13.
Please, the lordship, I apologize, I was on next minute. I was here, I was on next. minute.
No, that's all right.
Lordship,
Yes.
this is a regular appeal, it is an appeal filed under section 415 of the BNS with regard to the conviction of the appellant.
This is item 13.
My lordship, 13.
Yes.
It's a regular appeal filed with regard to the.
So admit,
It is with regard to 3 years conviction. The appellant is presently on previous bail and I have also filed an IA
You are on bail.
on previous bail.
So that can be continued, Mr. Sharma.
Well,
Yes. In the appeal to me, admit any private respondent? Admit Mr. B. Sharma, let APP accept notice for the state respondent, extra copies. Let the case records be called from the court of the session judge, Charayo Sunari.
Soraido, my lordship.
Soraido. Sunari and list after 3 weeks or 4 weeks, return 4 weeks.
I apologize, lordship, not Sunari, only Soraido.
No, it's written here.
the district headquarters is Sonali.
Soraido.
District headquarters is Sonali.
Session judge, right, my lordship.
IA to sir. In the I beleg ke likhe ba. Heard MS SG Barua.
My lordship.
Learned counsel for the petitioner also heard Mr. B. Sharma, learned APP for the state respondent. By way of this application under section 430 of BNSS 2023, petitioner is seeking, no, not petitioner, applicant is seeking, applicant I, naam to koi diba, I Shri Mithul Tapna, Alice Shri Mithun Tapna, is seeking for suspension of the sentence passed by the Honorable Court of Session Judge Soraido in session Cha case number 05/2018 under section 325 of IPC, convicting the accused appellant persons to undergo imprisonment for a period of 3 years and to pay a fine of ₹2,000 in default of payment of the fine to undergo further imprisonment for a period of 1 month. It appears that the applicant was in bail during the trial and has not taken any undue advantage of the bail granted earlier. It further appears that the learned session judge Soraido on 14/5/2025 allowed the applicant appellant to go on bail under section 3893 of CRPC for a period of 2 months, and as such, while passing the impugned conviction, and accordingly, the applicant is presently on bail. In view of the above, the interrogatory application stands allowed by allowing the applicant to remain on previous bail as granted by the learned trial court by judge by order dated 14/5/2025. Disposed of, pending adjudication, and the sentence is also suspended. Judgment in so is suspended until pending adjudication.
For orders, item number 16 and 17.
Yes.
Lordship, although it's a 2021 matter, at that time, POCSO, if there was POCSO, then also informant party is not necessary. But as it is necessary now, Lordship, on the last occasion, Honorable Court directed, as I am for the amicus, so
Report.
registry, or in 2 cases, one registry is directed, in another case the council, because that is represented by the council, where directed.
2 cases.
Yes, Lordship. In the first one, I am appearing as an amicus. Yes. So now.
Yes, report, Mr. Sharma.
Report not received.
In both.
In both, madam.
You have reports.
In
Same
one method,
informant.
in one method, I think, my lord, report will come from the registry.
No, not registry. This is POCSO matter. You contact the jurisdictional police station. In both matters, they Bhargav, Belek Beleke likhi diba. Her etat likhiba heard MS B. Sharma and amicus curiae, Mr. B. Sharma learned APP for the state respondent, are at that MS?
FN Hussain.
Huh?
FN Hussain.
FN?
Hussain.
Hussain, item 17, na? MS, or B Sharma. তাৰপিছত দিবা দুটাতে Mr. B Sharma learned APP assures that the report as regards the service of notice upon the informant shall be positively placed before this court by the next date of listing. Relist on such and such date. Yes, some adjournment was sought in this matters.
I remember 18, my lord, they have sought adjournment. And
Yes.
This has come up for orders. This will go for hearing, my lord.
It's paper, the case records
Case records are here, my lord.
are here.
Case records are here.
আহিছে না case records? এতিয়া লেখক যে in Mr. Nawaz, you're appearing in which one?
20, my lord.
20
20.
in item 20 to first Lubo. Heard Mr. S. Nawaz, learned counsel appearing for the appellant. Also heard Mr. B. Sharma, learned APP for the state respondent. The case records as called for has been received. Case is ready for case is now ready for hearing. List the matter for hearing when?
My lord, August, my lord, any date in August, my lord. Already in jail for 2 years, my lord.
September 2025 on any date to be fixed by the registry. And in item 18 and 19, where are the counsels gone? 18, 19 to ekelage yaar logote koi thoi diba. It can be one common order.
Common order, my lord.
Same paper book.
Same paper. Paper book is not there, my lord. Records are there. Records are there. Paper book is not there.
Book is there.
Not same paper.
Oh, sorry. Paper book is not, but the same record.
Record, same record. Keep clear, my lord.
Yes, Mr. Bora? Barwa. I get confused with Barwas and Bora. And also Sharmas with the H and not the A. Yes.
Actually, what happened when the last occasion, my lord, their new address we have got, and accordingly we have taken the step. That steps is awaited. Awaited, and I had the IA, my lord. at the
For
time,
suspension.
For bail, my lord.
But so let the surface get complete.
Already, my lord, he has in the jail. Both the petitioners were in that jail.
What
for
to
one-
do?
one
R2
year.
is the informant.
Informant, my lord.
Await service, relist, give a date on such and such date.
Bail may be considered since, my lord, what happened, my lord, at the time of the
Let the service be completed, Mr. Barwa. Yes.
date to do? 25th of July.
POCSO. Report.
Proceed, kindly pass over.
Wait. Yes, report.
My lord, I have inquired, my lord, but yes, my lord, answer not from report not that this, my lord.
Mr. Sharma, sorry, I'm not following what you're
My
saying.
lord, report not this, my lord.
Report not received. Mr. B. Sharma, alert APP submits that despite his best effort, he could not obtain the requisite service report as regards the informant. However, he by way of a last chance, by way of a last chance, he seeks further accommodation. Relist did your after vacation on such and such date. Miss Counsel, there is there is nothing that your senior can come and improve. This information needs to come first.
24.
Your Lordship, I'm submitting on behalf of Mr. S. Das. Kindly adjourn the matter, Your Lordship, for today, Your Lordship, for some personal.
As prayed for by Mr.
S. Rahman, Your Lordship.
S. Rabha.
S. Rahman, Your Lordship.
Rahman. Learned counsel for the appellant.
Yes.
Relist.
After vacation. Your Lordship.
Relist after 2 weeks on a date to be fixed by the registry.
Problem.
Yes, Mr. Barbuia.
Yes, ma'am.
Suspension.
May I please?
Suspension.
My lord, no, my lord, it is, my lord, appeal, my lord. I am
Huh?
trying to release the appellant before your lordship on bail, my lord.
Bail.
Bail, my lord. Here, my lord, as per my little understanding, my lord, this prosecution, my lord, totally failed to prove any case.
So you, what is the conviction? How many
10
years?
10 years, my lord. Two brothers, my lord.
10 years.
Yes, my lord.
And since when are you inside?
My lord, December 2024, my lord. Here, my lord, mother and sister also.
Offense is under 307326.
Yes, my lord. Two brothers, my lord.
Grave offenses.
After
Yes, Mr. Barwa?
After 1 month, my lord, FIR was lodged. my lord.
Offense is very serious in nature, my lord.
But
And
sir,
second,
Right, we'll consider it after vacation. This matter have to be seen. So relist after 2 weeks on a date to be fixed by the registry. Yes,
oblige.
POCSO.
May I please enter, sir? In this case, I may appear for a respondent to informant, my lord.
You are appearing for the informant.
Yes, my lord. I pray for 2 weeks' time for filing our objection.
So service for R2 stands complete then. Heard Mr. Dibora, learned counsel for the appellant, also heard Mr. RJ Barwa, learned APP for the state respondent, and Mr. Huh?
DJ Mehdi.
DJ Mehdi, learned counsel appearing for
For the respondent to.
the respondent number 2. Mr. So-and-so seeks
2 weeks' time
2
for
weeks time to file
objection, my lord.
objection. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. Will come, yes.
May it please your lordship, the name of the counsel for the respondent number 2 is reflected, my lord, in the cause list.
Not reflected.
Reflected.
Yes.
Lordship, I have a prayer here, my lord. In this I have raised the plea of juvenility, which was not raised during the course of trial, my lord. So I am praying that in support of my plea, I have annexed the Aadhaar card and the school certificate, my lord, which shows that I was a juvenile on the date of commission of the offense, my lord. So I'm praying that this honorable court may direct an inquiry by the JJB into the juvenility of the accused person.
But this is a criminal appeal.
My lord.
This is not the appeal convicted already.
Yes, my lord.
Records have come.
records have come on. 27, no, 27. No, records have not come. my lord.
Not come.
The plea was never raised, but if your lordship kindly looks at the
Records have been called, they have not come, Mr.
The
Dev.
record come, my lord. Wait.
Yes, the trial court records as called earlier has not yet been received. Issue reminder, relist after 2 weeks 3 weeks on a date to be fixed by the registry.
Much obliged.
Yes, Mr. Chaudhary.
It was, but that matter came,
I didn't see you. I saw the junior Chaudhary. So that is why I was referring to him initially when I said Mr. Chaudhary.
So
Yes, yes.
it is a matter of 4 years. Already appeal admitted, my lord. It is just a small, my lord, just a note.
Yes.
Yes,
Conviction.
yes. No, it is objection already filed, my lord.
Hmm?
Oh, sorry, there is no need of objection here, my lord.
Are you-
4 years, my lord.
4 years.
4 years, my lord. If it already admitted, my lord, then short term, I hear that your lordship may grant everything I have, my lord, annexed.
I'm sorry, I'm not understood. You are saying?
My appeal is since appeal already been admitted, my lord. So far bail is concerned, normally 4 years up to 5 years, normally this court is inclined to, my lord. In the initial stage, but now, my lord, already I have given and that your lordship has given opportunity to go through the annexure. And they have gone through that, my lord, I think, my lord, normally short term period, my lord, normally bail is allowed. That is what I am submitting. Once appeal is admitted, then there is no chance of appeal hearing.
Only my lord, problem is the answer has not come.
No, that is, I have given everything. Your lordship direction was there, so last time.
Have you verified?
My lord, the answer has not come. my lord.
No, they have given
Yes,
some
yes, my lord. They have
documents.
Yes, my
They have annexed the evidence of witnesses, my lord.
Have you gone through?
Not each and every witness, my lord. Don't go, my lord.
Then we will issue a reminder. We'll get it soon. It appears that the case records as called earlier has still not been received. Though the appellant has this is what you are submitting.
Madam, no, this that note I have given, madam, just date
I
of,
submitted the evidence of few of the prosecution witnesses. However, since the entire evidence is not on record, it is, it is,
No, my lord, I have submitted all the records, man.
Mr. Chaudhary, Mr. APP is saying everything is not there.
Yes, it is there, my lord.
My submission is that, my lord, he has annexed all the deposition of all the witnesses, including the judgment in the IA petition, my lord.
Oh.
But, my lord, I have not been able to go the evidence of.
So that he
all
was
the
there.
witnesses.
You have not been able to go through.
No, my lord.
Then you go through it, I'll fix it on the reopening day.
My lord, tomorrow, my lord, because you're lost. My lord,
Um,
63 years old, he's not.
Okay. You say that, in view of the order dated, in view of the last order that I 23/6/2025, the photocopies, Mr. Borwa, these photocopies were already there.
Yes.
Why are you taking so much time to go through it?
My lord, this is the appeal, my lord. So I have to.
Yes, but it is already there. In fact, last, the matter was last,
My lord, let it come tomorrow, my lord, I'll go.
you have a look at it.
Tomorrow, my lord, I'll go.
On the prayer of Mr. R.J. Barwa, let's so relist tomorrow.
Obliged.
এইটো এবাৰ মোক এই কেছ লটে দেখাই দিব।
This is just list of dates, my lord. I have given that.
29.
There is one decision, Mr. Chaudhary, if it is less than so many years,
Given that.
have given that.
Yes, just now I have. 2-3 judgment there. This one, coordinate bench also passed the order, madam.
That also, huh?
Yes, already given, madam.
One, I think only one has been given. If you have one,
Another of this.
give it to the court master, Mr.
That
Chaudhary.
also you give. All right. The several Supreme Court judgment are referred also, madam. in this case.
All right.
May I please, Lordship? Lordship, the appeal is admitted, Lordship. Here is the IA, Lordship, for consideration, Lordship.
POCSO.
Lordship, the.
Mr. Diori, you are appearing? Yes?
Lordship, the
Conviction is under section 6(4).
Section 10. Section 10, Lordship, for 5 years, Lordship.
5 years.
5 years, Lordship.
Judgment order dated?
Lordship, 22/1/25.
Oh,
22/1/25, Lordship.
this is a POCSO matter. In fact, during trial also, the general presumption of innocence is not there. Now, though it has been convicted, it has become more stronger. Why should this court now suspend the sentence?
Lordship, the relation between the Lordship, the victim girls and the appellant is Lordship. The victim girls are the class 6 and 7 student, Lordship. And here is the appellant is the teacher, Lordship, social science teacher.
POCSO
Such.
came.
But I'll show from the judgment, my lord, that the prima facie my conviction and sentence, conviction is wrong, my lord.
Who is appearing for informant?
Amicus curiae.
Legally.
Legally.
MS Das. It will same order disposed of. Only that name to change. Only I think the name will get
Only
changed.
name, madam.
You take
Rest
my
is
order.
there. Case number, madam, would be, it is not there.
Only the name part, I think, right?
Yes, only name.
Huh?
Only name and rest same, madam.
What will be the name?
Yes, name Makbul Ahmad.
In naam to underline course, it will petitioner per likhile ba. Paragraph 8, isn't it?
Yes, yes.
That is the only change,
Only,
correct?
yes, madam. The rest are same.
And the names of councils. Instead of Giuddin, to Hugo, Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by R.M. R.A. Majumdar. Learned Counsel for the appellant, also heard Mr. R.J. Barwa, learned APP for the state respondent. Paragraph 5 to দরকার নাই আৰু 6 B Sharma জায়গাত RJ Barwa কৰি দিবা মই আন্ডাৰলাইন কৰি দিছো paragraph 4 HRH shall be paid in senior counsel.
Main appeal may be come up for hearing.
I hear this full much.
I disposed of. Appeal list for hearing in the usual course.
Obliged.
Maybe lordship. So I will hearing on behalf of respondent too. On behalf of respondent too.
Yes,
I will file Okolab.
you will file your wakalatnama.
Yes, lordship.
Heard, Mr. Kalita, Learned Counsel appearing for the petitioner. Also heard, state is there, Mr. B. Sharma, Learned APP for the state respondent, and Mr. R. Ahmed. R. A. Ahmed, Learned Counsel appearing for the respondent number 2. In view of the fact that Mr. So-and-so Learned Counsel has submitted that he is going to file wakalatnama in the course of the day.
Within 2 days, tomorrow.
Within 2 days, on behalf of the respondent number 2, service in respect of respondent number 2 stands complete. List the matter for admission.
For admission.
For admission,
But there is an order also on last occasion, it was reflected in the order that interim prayer will be considered.
yes, but he's just appeared, he has not even filed it. So for admission, give a date after 2 weeks. And on the next date, the interim prayer, as directed earlier, shall be considered.
Lodge.
Obliged.
In this case, on the last occasion, record was called for. And basically, we are challenging in this criminal petition with regard to the.
Scan copy, he said. Not received.
Well, Lordship kindly peruse the last order.
After scan copy, await scan copy of the case records as called earlier. Issue reminder, relist after vacation video.
Can a date be fixed?
Yes. Which is 15.
May please, Madam. This petition filed for quashing of FIR charge as well as proceeding of PRC case number 422 of 2021, pending before CGM Baksa, my lord. My lord, there is development, my lord, that was compromised, my lord. Case was compromised, my lord. Here is an affidavit, my lord, I have annexed, page 20.
You are for the informant?
Yes, I am for it.
Compromised?
Yes, compromise one.
Yes.
Page 26.
Is this a joint application?
No, my lord, I have filed separately. I have made respondent number 2, my lord. Inform.
Yes, where is the affidavit?
Page 26, relevant portion is page 27.
So, no.
Page 27, my lord.
Yes.
Para 3, my lord. That the deponent as well as the accused belong to the adjacent villages, and on the intervention of elders of both the villages and well wishers to maintain peace and tranquility in their locality, and also the respective families of both the informant and accused, they intend to compromise the matter. Further, the deponent has voluntarily come forward to compromise the matter with the accused, namely Banjit Pali family.
What was the offense?
Thanks, my lord. 447, 427, 354, 294, and 506.
Non-compoundable is
Yes.
which one?
354 and 294.
354 and
294, my lord.
290.
294, my lord.
294 is there.
Yes, ma'am.
Yes, Mr. Sharma.
There two sections, there is the two section by not compoundable, madam. 54
And
294.
I don't find 294.
My lord,
Oh,
last,
it's there.
last one, my lord.
Yes, 290. Yes.
294, there is two.
Yes, but they have compromised.
Yes.
What is to be done in the ends of justice?
Yes, my lord.
Where's the FIR?
FIR is page, my lord, 13, 12, my lord. Annexure 1, my lord. May I read, my lord?
Yes.
Page 12, Annexure 1. With With due respect, I beg to state that today evening at around 7:30 p.m., the above mentioned accused person suddenly attacked our house situated at Ohopa carrying iron rods and knives. It is to be mentioned that at the time of incident, my husband, Sri Manovendra Das, was absent in our house. It is further stated that the said accused person trespassed into our house without permission and vandalized the household furnitures and items, and they pulled and dragged me and used obscene languages. For your kind information, I wish to state that the accused person tried to drag me towards the forest located behind our house. Fortunately, at that time of the villagers came out and the accused person fled from the scene.
Allegations are very strong.
Case was registered under 447.
There is search also, my lord. Right, in this case. So there is some materials, my lord. Prima facie there is materials.
Because this cannot go on like this. Today they want, they will file. Tomorrow they'll compromise such non-compoundable offenses and then they come by way of petitions.
Search my lord, search maybe, my lord.
My lord, I have one judgment of Bombay.
Tomorrow during trial, if there is nothing, no evidence, it will automatically be concluded.
I have one judgment of Bombay High Court, my lord.
After vacation, you keep this later. I am not inclined in this.
Yes.
If I'm right. Yes,
Yeah, my lord, in this judgment, my lord.
after vacation.
Also.
Please, your lordship. Lordship, as per the last order dated 11/6/25, service on the sole respondent is still awaited, lordship.
Await service in respect of?
Sole respondent.
But he is there.
Lordship, but it was recorded as respondent number 2 in the order.
No, but
I'm appearing for that.
he's appearing.
Okay, he's appearing.
So you're appearing for the sole respondent? Heard Mr. H. Das?
No, D. Borua in behalf of Mr.
D.
Ishtar.
Bora, Learned Counsel.
D. Borua.
D. Barua, Learned Counsel appearing for the petitioner. Also heard Mr.
B. Das.
B.
B. Das.
B. Das. B for Bombay.
Yes, lordship.
B. Das, Learned Counsel appearing for the sole respondent. In view of the appearance of Mr. Das for Learned Counsel for the sole respondent, service in respect of the sole respondent stands complete. Yes, I'll fix it for admission.
Yes, lordship. Today I filed my wakalatnama.
Mr. Das also submits that wakalatnama has been filed today. Let registry verify and place the same on record. List for admission after 3 weeks.
That means if your lordship, matter is of 2019. Yes, sir.
Yes, next.
Oblige.
My lord, this is for investigation of the case.
Scan copy ahisa? Ahisa?
Yes, my lord.
AD card R2. R2 is still awaiting.
But we have expected.
It appears that the scan copy as called for from the trial court, scan copy of the trial court record as called earlier has been received. However, service in respect of R2 is still awaiting. List after 2 weeks.
In the meantime, my lord, my petition was arrested.
Yes, next. Yes, Mr. Biswas.
I am before your lordship for bail, but IA, 7 years conviction 304B. But at the.
In the appeal, case records have come.
Yes, appeal has admitted already.
No, the last order says TCR not received, PCR ahil lena. So appeal is not admitted. Ahila. Who is appearing for the state? Have you seen the case records have come?
Not seen, my lord.
So have a look at it because Mr. Biswas is pressing the interlocutory application for suspension, right?
She died, but medical evidence is that we could not ascertain the cause of the death.
IA2, sir?
We could not ascertain the cause of the death.
I have also lost the FIR after her death, my lord.
So the conviction is for how many sentences?
7 years,
Huh?
7 years.
All right, Mr. Sharma, you have a look at it, reopening immediate, in the IA, like, Marshal, please take
Your
it.
case, your lordship will get.
And the IA that,
Bail already.
yes, but let Mr. Not a connected co-accused.
No, they have been acquitted, father and mother acquitted. Only son has been convicted.
Mr. B. Sharma, learned, B. Sharma, learned APP for the state, seeks a short accommodation to go through the case records in order to oppose the prayer made in the interlocutory application. Prayer is allowed, release, give a date immediately after vacation on such and such date.
15.
16, is it okay?
Operating.
Main case to sub-appeal.
Please, your lordship.
R2, case records. Service, I think, is still awaiting.
Case reports has come, your lordship.
Ah?
On last occasion, your lordship, respondent number 2 has engaged counsel and no one appeared on call, your lordship.
Appeared?
No one appeared on
No
call.
one appeared.
Yes.
But no, it appears notice has already been served. But none appears. So I'll appoint someone.
Someone may be appointed.
Yes, Mr. Pathak, would you like to assist the court and represent the informant R2 in a criminal matter? It appears that though the notice has been served upon the informant respondent number 2, however, none has appeared consecutively for the last 2 occasions when the matter has been called. In view of the same, Mr. KP Pathak, learned counsel, is appointed as an amicus curiae to represent the informant stroke respondent number 2 in the instant interlocutory application and the connected criminal appeal, accompanying criminal appeal. Let copies of the appeal memo as well as the interlocutory application be furnished to Mr. So-and-so by the petitioner within 3 days from today. Let
Take something, lordship, in the trial court, on 3rd of every month, the matter is fixed for report. And on last occasion, due to the non-continuance of bail by the Honorable Guwahati High Court, the convict was about to be arrested, lordship, and the lower court has told us.
no, now, unless somebody represents the R2, it's a criminal matter. So let it be, I'm posting it after the vacation. Let him have a look at it. You give him all the copies. What was the last sentence? Along with the IA and so be furnished to so by the so, and then list when after vacation, list on such and such date. Let registry reflect the name of Mr. KP Pathak in the cause list, learned amicus curiae in the cause list. What is the correction?
My correction is that, my lord, yeah, my lord, lordship, kindly.
Numerical correction.
Yes, actually it is my judgment of my lord 30/12/2023, my lord. Trial court judgment, but it has become my lord 24, my lord.
The judgment is actually 30/12.
Yes, my lord. 30/12/2023, my lord.
Where is the where is the
Judgment
order?
next, my lord, in the IA, my lord, it is my lord, page 15, my lord, relevant POCSO.
Page
15, my lord.
50.
No,
One.
1515, my lord.
So this is this correction that you are seeking is in this IA.
IA, my lord.
IA and okay. 15. Page?
Page, my lord, in my current, my lord, IA page 15, my lord, judgment date 30/12/2020.
That I have got it, but in this court judgment, where is the correction required to be
Yes, my
done?
lord, this is my lord, order I have annexed page 10 annexure A, my lord.
Oh, I think at page 12. It is mentioned as accordingly, the operation of the impugned judgment order dated 30/12/24.
Yes, my lord.
That should be 30/12/23.
23. And two other places are also mentioned, my lord.
Where?
My lord, it is, my lord, paragraph, first paragraph and second paragraph.
First paragraph.
30/12/2024 and.
No, in the first paragraph, I can't find 6(3). 30/12, yes.
Second paragraph, my lord, second line, 30/12/24.
Print first, oh yes. Why, you didn't verify these dates. It's all coming 30/12, this is that order. So 3 places.
Yes, my lord. It may be read as, my lord, the 30/12/2023, my lord.
Yes. All right, heard Mr. A.M. Barbhuiya, learned counsel for the applicant. Stop. Also heard Mr. R.J. Barwa, learned APP for the state respondent. By way of this application, the applicant is seeking correction in the order dated 24/6/2025 passed by this honorable court in IA criminal number 671 of 2025, in criminal revision petition number 233 of 2025. Whereby the petitioner was granted bail during the pendency of the said connected criminal revision petition. Stop. It appears that while typing out the judgment and order, while typing out the order dated 24/6/2025 in the aforesaid interlocutory application IA criminal 671 of 2025, inadvertently, the date of the impugned judgment and order passed by the learned additional Chief Judicial Magistrate Hailakandi in criminal appeal number 6/2024 was mentioned as, sorry, not that one. Sorry.
In NI case number.
Correct, I got it. Sorry. Mushroom. Wild type. What did you say? Wild? An order dated 30/12/2023 passed by the learned additional Chief Judicial Magistrate Hailakandi in NI case number 61/2019 was mentioned as 30/12/2024. Stop. Accordingly, in the first, second, and the last, and the second, I think it is very difficult if I say like, accordingly, the date of the impugned judgment and order dated 30/12/2024 shall read as 30/12/2023. Huh?
Yes, passed by the additional Chief Judicial Magistrate.
Huh?
Passed by the
Passed by the learned additional Chief Judicial Magistrate. The IA stands disposed of. This order shall be treated as a part of the order dated 24/6/2025. That should be the disposed of. Sorry, Mr. Barbhuiya. Typo errors happens.